Welcome to Advocating for Dads with Jana Jones.
Welcome back to Advocating for Dads with Jana K. Jones. Jana is a North Carolina family law attorney based in Charlotte. She has over 15 years helping fathers protecting their rights and preserve meaningful relationships with their children through divorce and custody disputes. I'm Lisa Mosby, and today we're discussing custody modifications. Jana will explain when a court will reconsider an existing order and what fathers need to understand before filing in North Carolina. Welcome back, Jana.
Hi, Lisa. How are you?
I'm good. Jana, in North Carolina, what legal standard must be met before a custody order can be modified?
Sure. So the magic kind of term in North Carolina is substantial change in circumstances since the entry of the prior order that affects the welfare of the minor child or children. So essentially, what that means is something major has to have happened since that last order was entered to give the court the power to be able to change the order and make a new best interest determination.
And then what qualifies as a substantial change in circumstances under the law?
Sure. So it's pretty subjective. The judge has to determine that. But it could be a myriad of things. It could be something's happened with one of the children, maybe behavioral issues, or their grades have gone down or started to slip. It could be that one of the parents is going to be moving to a new jurisdiction, a new state, or maybe even just a new city, and that's going to have an effect on how the current order can work. It could be there's been some allegations of abuse or neglect by one parent towards the other. So anything that gives rise to something that's different, some circumstances that are different from the time the order was entered before to the present time could be enough for a substantial change in circumstances.
So I'm curious, does the change have to affect the child directly, or can changes in a parent's life be enough?
So it could be changes in the child's life or the parent's life. The change has to be substantial and it has to affect the welfare of the minor child. So it could be, a parent got remarried and they're moving to a new state, or they got deployed, or something that has nothing to do specifically with the child. But that change from the parent is a substantial enough change from where things were when the original order was entered. And that is going to affect the welfare of the minor child.
And then how recent does that change need to be for the court to consider modifying custody?
So it needs to be relatively recent. If too much time has passed and there's a new normal, there may be a substantial change, but that welfare piece of it, and what the court decides to do with it may look like what you guys have come up with. So, for instance, let's say you have an order that says one parent gets every other weekend, and both parents were local when the order was entered, and then one of the parents moves to, say, Florida. Every other weekend is going to be pretty hard to pull off between North Carolina and Florida, right? And so maybe the parents on their own decide, well, you've moved in the summer. I'm going to let you get the kids for the summer, and they're going to spend the summer with you and then be back up here during the school year with us. And we're not going to do the every other weekend schedule anymore. And that goes on for a period of time. And then one of the parents decides to file a motion to modify based on a substantial change in circumstances. There has been a substantial change, but now you've you kind of made a new normal with it. And so when you're talking about best interest determination, it's probably going to end up lining up with what you guys have been doing thus far, because the polar star in custody cases is the best interest of the child or children. And a lot of what that is comes down to consistency. So if you created a new normal for the child or children, that's usually what the court is going to want to implement on a ordered basis.
And then if a parent believes the current situation simply isn't working anymore, is that enough to justify filing for modification?
No, usually not enough. I mean, you can file for a modification. There is no harm in that per se. The question is whether or not you'll have a substantial enough change in circumstances to give the court the right to change the order. Because if a judge cannot find substantial change in circumstances, they cannot change the order. So if it's simply, I don't really like this schedule anymore, or I wish my child didn't have to spend that kind of time with the other parent, but there is no substantial change since the entry of the prior order, generally that's not going to be enough to get a change.
And then, Jana, how do courts evaluate relocation, remarriage, or a new work schedule when they're reviewing modification requests?
Sure. So I would say when it comes to remarriage, that generally is not going to have an effect. It's always important to note that the court determines where the child or children live, which parent, how long, what the schedule is, but they cannot dictate what an adult does. So an adult can move, an adult can get remarried, and all of that does have an effect on the child, but there is no order that can tell the adult what they can do, right? So if an adult decides to get remarried or to get married, and the actual order is still able to be effectuated, then there wouldn't be a substantial change there to give the court any real reason to change the order, unless that new spouse is somehow posing maybe a risk to the child in some capacity. Then that might be a substantial enough change for the court to feel like they have enough to change the order, and to do a new best interest determination. But getting married to someone on its own is not going to be sufficient in most cases.
Jana, sometimes it helps us to understand these ideas when we have an actual case. So, without sharing any confidential details, can you maybe describe a situation where a parent believed a modification was justified, but the court ultimately disagreed, and explain why?
Yeah, so I would say probably the one that sticks out the most was a relocation case. Relocation cases are extremely difficult, because when you have, especially if you have a schedule that's joint, or somewhere close to being a joint custody arrangement. I had a client who wanted to move cross country. She did not have a lot of support in Charlotte. Her family was in the state that she wanted to move to. She had a ton of support out there. She had much better job opportunities out there. Her child was in some extracurriculars that would have given her more advanced opportunities out there. Everything on paper would have been so much better for her and for the child if she was able to relocate to where her family was. The only thing that was here was the father of the child. Otherwise, nobody else, no other family, was here to support either parent, frankly. Unfortunately, that was not enough for the court to allow the mother to move with the minor child cross country. The court is tasked with determining best interest, and what they always use is going to be that each child and each parent needs as much time with each child as possible. So, if the court changed the order and allowed her to move, the joint custody schedule that they had previously been operating under would no longer be viable. And the court found that it would be in the child's best interest for the schedule to remain the same versus all of the pluses of her being able to move cross country. And that's a really challenging situation. When folks come to me on relocation cases, I'm very candid that you are fighting an uphill battle. And even if the other parent isn't the greatest person in the world or is doing some stuff that you're not particularly happy with or you don't think is great for the child, but it's not something definitive that we can point to as harming the child explicitly, then generally speaking, if you come in and you have a joint custody arrangement and you want to move to a location that's not going to allow for that to be maintained, you have to know that it's highly unlikely that the court is going to agree and let you move to that new jurisdiction.
Boy, that challenges my thinking. If you have a support system and people who can help you surrounding you, it seems like that would be better for the child. And I understand you want to have that relationship, mother and father too. But the person who has custody of the child also needs to be able to afford to take care of them and provide for them. Do you have any personal opinion on that?
Sure. In my personal opinion, in that case, I think she should have been able to move cross country with her child. Absolutely.
Yeah.
But
Yeah, it's
unfortunately,
so tough.
I'm not the judge, right? And I
Right.
didn't write the statutes, and the case law surrounding it. But yeah, I mean, it's a frustrating position for a parent to be in, especially when you have an order where you have joint custody on paper, and maybe that other parent is getting the child, but the reality is you're still doing all the heavy lifting, right? You're the one taking the child to extracurriculars or doctor's appointments or doing homework or tutoring, and you're really the primary parent. And in her scenario, she was really trying to work with him. She was offering significant time in the summer to try to make up for how much time he would be missing out on, and he was not interested in it. So unfortunately, we couldn't settle it, and we ended up going to trial. And unfortunately, the judge agreed that, or believed, I should say, that it would be in the child's best interest for her to remain in North Carolina so that she could have that same custodial relationship with both parents.
And you mentioned going to trial. What types of evidence tend to carry weight in a modification hearing or trial?
So I tell folks your testimony is your most important piece of evidence. If the court does not trust you or believe you, if you don't come off as credible, that is more damaging than not having a exhibit A for some text message that you claim somebody sent. Um, Outside of that, your testimony, then I would say when you're trying to demonstrate, what it is that you're claiming is to be the substantial change, you want to have evidence to that end. So, for instance, if you're saying that since the entry of this past order, things have changed with my child's schooling. They were previously an honor roll student and now they're failing, or they were previously, a happy kid, happy go lucky, and now their disposition has changed. They're in therapy. The therapist is concerned with the behaviors or something along those lines. Those are things where you could subpoena a therapist to come in and testify. You could introduce records related to school records, right? Grades and things of that nature. So exhibits are there and evidence is there to illustrate your testimony, but your testimony will always be your most important kind of piece of information for the court to consider.
And then, Jana, where I want to wrap this episode up today is for fathers considering filing, what strategic considerations should be evaluated before taking the case back to court?
So make sure you've got a substantial change. Make sure you've got a reason to give the court a basis to make a change. And also keep in mind that even if there's a substantial change, that gives the court the right to change and the right to make a best interest determination. But sometimes the best interest of the child is still going to be served with the order remaining the same, right? So in that relocation case that I mentioned, that was essentially the court's perspective. There was a substantial change. She was wanting to move cross country to be with family. But ultimately, from a best interest determination, the court found that the best interest of the child would be served for her to remain in North Carolina so that she could have the equal custodial time.
Jana, thank you for your insights and your guidance today. That's it for today's episode of Advocating for Dads. If you have questions about whether your situation qualifies for custody modification under North Carolina law, visit lawofficeofjkj.com to schedule a consultation with Jana and her team. Thanks for listening, and don't forget to subscribe, leave a review, and please share this episode with a North Carolina dad who could benefit from today's conversation. And we'll see you next time.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.